Good morning. My name is Mark Trummel and I serve as the Vice Chair of Virginia Ability. We are pleased to present our annual ADA Legal Update webinar focusing on returning to work. Performance Food Group is proud to co-sponsor this event. Steve Brown, a partner at the law firm of Eisler Dare, is our featured presenter. Steve brings 30 years of labor and employment law expertise to our audience. He also provides practical solutions to complex legal problems in the workplace. In terms of housekeeping, we will have 3 poll questions at the end of the presentation. Please save your own questions until the end. When the Q&A begins, you can enter them in the question box feature. Also, the slides referenced by Steve will be sent to all registrants after the webinar. Since we have a full agenda, I'm going to let Steve begin.
Good morning, everyone. It's good to see everybody for a second year. Thank you for having me back. I'm looking forward to walking you through a number of things in this hour that we'll be together. Here's our agenda. We're going to talk about whether it is attendance at the work site an essential function of the job. We're going to talk about conducting the interactive process for continued teleworking, if that's an option. We'll then look at some mandatory vaccine issues, which is a hot topic, much hotter than I thought it was going to be when I drafted this in June. But now that we're in the latter part of July with the new CDC guidance yesterday, we now have a pretty hot mandatory vaccine debate going on. And then we have a case study that will deal with the essential functions of the job and and the fitness for duty exam requirement if the employer is going to use that. So let's jump right in. So is attendance at the work site an essential function of the job after you've been working remotely during the pandemic? This is going to be a hot topic. It's starting to get hot. We have not seen any cases yet on this, but there have been plenty of activity. And when I say plenty of activity, I've received numerous demand letters on behalf of employees for my clients dealing with this exact issue. Does this employee really have to come back to work? And the arguments that I'm getting are that you did just fine as an employer for the last 15 or 16 months having this employee perform the essential job functions. So why do they suddenly have to come back? So we're going to look at what is an essential job function. And the EEOC regulations define them. These are the fundamental job duties of the position. And they don't really deviate much unless you have not put these together in a job description or you don't have them in some document. The employer is responsible for determining what those fundamental job duties are. If you leave them up to the employee, you're going to have a dispute because your employee might have a different understanding of what those essential job functions are. I encourage job descriptions for my clients. I think it's the clearest way for employees to understand what the job is, and it's the clearest way for the manager to understand it. So I would encourage you to do it. If you're going to have a job description, you really have to outline what those essential job functions are. And we look at a couple things. We look at the reason that the position exists to perform that function. We look at, the number of employees that are available to do that. Is it a highly specialized or highly, sought after type of a job that needs expertise? Most jobs are easy to define. So for example, if we're going to look at the job that I have as a lawyer in a law firm, there are ways to come up with the 5 to 7 essential job functions that I have. That's about it. Most people have between 5 and 7. Job descriptions that are 3 pages long usually have other things that are not essential functions. So you really need to carve those out so the employee understands what's essential. So we look at a couple factors. The employer's judgment is primary. I like to work with the employees when putting these together. When we're putting together our job descriptions, it helps if you've worked with the employee. You don't have to. As an employer, you can mandate what those functions are. But I can tell you, if you work with your folks on what you believe to be the essential functions of the job and what the employee believes to be the essential functions, there's not a whole lot of dispute. Just because you've allowed somebody to work for the last 15 or 16 months doesn't mean that you're now stuck having that person work remotely. There has to be a valid reason for that person to continue to work at home. It has to be an issue that's associated with either a serious health condition under the Family Medical Leave Act. If you're an employer that has enough employees to qualify, remember that's 50 employees within a 75-mile radius. But predominantly, we're going to be dealing with is somebody with a disability. They will be covered likely under Virginia law, and probably under federal law, depending if they meet the federal employee standard. If they do have a disability, you should be engaging in the interactive process with them. And this is an important piece. A lot of employers skip the interactive process. I always like to say that a lot of human resources people have taken the human part out of human resources. You need to sit down and talk with your folks. Most of these issues can be resolved with somebody with a disability by going through the interactive process with them. So let's look at some of the best practices that we have when doing the interactive process. And we don't speak enough about this. I'm doing a lot of training on this now all over the country on how to do the interactive process, because I'm finding people aren't doing it correctly. So I'm going to give you the outline on how to do it. First of all, the employee needs to ask for a reasonable accommodation. They don't have to use magic words to get there. They can say something like, I need help with my job. I can no longer do such and such job function. They don't have to use the magic words reasonable accommodation when they come talk with you. You then need to explore with them in a discussion. And that's not one-sided. You need to let the employee discuss it. Many times the employee has a great idea for what your reasonable accommodation should be. And it's an idea that you as the employer can probably adopt with no problem. So I would encourage you to have a real discussion, not just a one-sided discussion in a conference room where you as the employer are dictating the terms. Let the employee talk. I think you'll be very surprised that folks with disabilities will come up with something that's probably even less of an accommodation than they really probably need, because they want to keep the job and they want to make you happy. And so let them talk about what they need. You don't have to make any accommodation as an employer that creates an undue hardship, but I can tell you undue hardship is extremely difficult to prove. And so if you're going to claim undue hardship, make sure you speak to a lawyer before you're going to really go with that defense. Most employers lose that defense because most things are not on an undue hardship. If there's not an obvious accommodation, you as the employer can say to the employee, we need your medical provider to provide us some additional information. That's perfectly fine to do. If the employee refuses, that's a problem for the employee. The employee needs to work with you on that. And so many times we're going to work with the employee's medical provider and we're going to work with the employee at the same time. So step one, recognizing the need for the accommodation. So has the employee communicated a need? We're going to be dealing mainly with teleworking, to continue teleworking as an accommodation for a disability. If that's the case, you need to document that request. As an employer, you should be keeping really good notes of these conversations. So if you're having the interactive process, there should be notes kept by the human resources person on what was said in that meeting. If you're not a good note taker, have somebody be in the room with you as an HR person that is a good note taker. Have that person take notes while you lead the conversation with the employee, because the record that you're creating may be important down the road. Our hope is that we're not going to be engaged in litigation with each other, but sometimes that happens. And so if there's going to be a lawsuit, what is documented as part of this interactive process is important. Consider the FMLA issues. So if you have an FMLA issue, the employee not only with the disability has the disability, but they also have a serious health condition in most cases that will qualify for family medical leave. So you have to look at whether leave should be an accommodation or should the person be accommodated under the FMLA. So there's pieces that can kick in for FMLA, and I don't want you to forget about that. Step two, gather information. So locate, review the job description. Your job descriptions need to be kept up to date. Most employers don't keep them up to date. Jobs do morph over time. And so if you don't update and supplement those job descriptions, it's going to cause you a problem down the road. So you're going to want to keep those job descriptions updated. I like having employees sign the job description. Juries like that. So juries like when you're trying a case that if you've got an employee that signed a job description, it indicates that they agree with it. Now, whether or not that's true is a different story, but it allows you as the employer to argue that they signed the job description, which means they agreed to adhere to it. And does your job description mention regular attendance at the worksite? If it does not, you need to edit it and make the change. Your job descriptions as an employer should now, if it's true, require regular attendance at the worksite. If it's not true, and you've decided to move that job into more of a remote work, remote job, that's perfectly fine. but it should also mention that as well in the job description. If you're going to have a remote position, it should mention when you do require people to come in person. So good example I can give you is my son is a software engineer, and my soon-to-be daughter-in-law is as well. Both have been given clearance to stay in Richmond. They both were in Northern Virginia when the pandemic hit. They moved back to Richmond. Both have been told by their respective companies that they can work remotely and never have to come back, with the exception of 2 annual meetings and a retreat. And so they put that in both of their job descriptions. So it indicates to them, you are required to come. And the other part in their job description says, and if we need you to come in person, you must show up. So they have the ability to say, you can stay remote, but if we need you to come in, you need to come in. So if you've got regular attendance issues, make sure you put them in. And I would talk to the manager as well. Have the manager work with you on your job description. If the manager is insistent that attendance is an essential function, find out why, because that may not be true. And so you as the employer need to be sure that really attendance is an essential function of the job at the work site. Attendance by Zoom or remotely absolutely is essential, but do you really need them at the work site? The next part, step 3 that we're going to talk about is, as you're gathering that information, what are other employees doing in that situation? I think I skipped a slide, so give me just a second. I think I went too fast. Yes, what are other employees doing? Have other similar positions returned to on-site work? If they have, why have they? If they have not, why not? There's an ADA questionnaire that you can put together to the employee and have the medical provider complete it and return it. I advise you to use those and draft those so that the medical provider understands what the job is. Attach the job description to the questionnaire. What you're really trying to get at is get the medical provider to provide you information as to whether the person can perform the essential job function. So you need to continue to do that and use that type of a form. Now here's what you do when you meet with the employee. So I've given you a little bit of dialogue here. I may not read the whole thing to you. I've given you kind of a script on how to do it. And so I may just go through it quickly with you, but basically when you're sitting down with the employee, turn your phone off, turn your computer off so that you're not checking email. In our digital age, we all seem to want to multitask. As my son, I'll use him as another, as a good example. He's not on the call, so I can do it. As a software engineer, he has 3 screens up. He has a game on one, he has a movie on the other, and he has his work in the middle. And he claims to me that he can do all of it. Now, he might be able to. He's not on my payroll anymore, so it's okay with me if he does that because I'm not paying his rent or his food. It seems bizarre to me that he can do it, but my understanding is that's normal. In the industry he's in, a lot of people do that. So as long as they're happy with him, I'm happy. So when you're sitting down with them, though, turn off your devices and go ahead and start going through the information with the person. Make it as casual as you can. I always let the person sit closest to the door. So if you're in the conference room, I never like to box an employee into the office. So I allow them the ability to be able to get out. Not that they're going to run from you, but I think it's less intimidating. If you put an employee in the back part of your office against the wall and they can't leave, it causes more stress. So I don't like to put stress on people. And then sit down and have the conversation. And acknowledge it could be a difficult conversation, but you need to discuss with them their ability to perform the essential functions of the job with or without a reasonable accommodation. And then you go through kind of why we're here. You know, we had the pandemic. The pandemic is still going on in parts of the country. I'll submit to you they're going on in all parts of the country. We seem to be doing a little better in Richmond, in the kind of the central Virginia area. But who knows how this thing is going to take off. But then the company, you talk about how the company's been flexible with leave, how you've allowed people to work from home. And we now are really evaluating whether it's feasible to have people work at home any longer. And then, you know, if they ask what's really changed, you can inform them that some of all the restrictions have been lifted. The vaccine's readily available. You know, everybody's eligible to receive it. The company's restoring the essential job functions, and that includes on-site attendance. You may get pushback from folks on your on-site attendance requirement. I always like to tell folks that the conversation is confidential, but you also have to qualify it. And you have to say to the employee, but if you feel it's necessary for you to talk with your coworkers about this, you can do so. Now, I know that runs counterintuitive to probably what you're used to hearing. The reason we tell folks that if they want to discuss the terms and conditions of their employment with their coworkers is because under the National Labor Relations Act, everybody's covered by that law. And so whether you have a union or you don't, everybody's covered by the NLRA, and you can't tell employees to keep terms and conditions of their employment confidential. You can't tell employees that they can't have a conversation with their coworkers about how much money they make. They absolutely can. And a lot of employers make the mistake of saying, look, salary information is confidential. I'm going to fire you if you talk about it. If you do that, you violate the National Labor Relations Act. Then you discuss their request. Ask them some follow-up questions. Ask them about their medical condition. What's the limitation that's created by it? Is it a permanent or temporary condition? How does teleworking help you complete the essential functions of your job? Is there another accommodation that could effectively address the issue? Ask these types of questions with folks so that you get a good understanding of why the disability is requiring them to stay home versus out of fear. And we'll talk about that in just a few minutes. If they claim they're nervous about coming back because of COVID-19, or they're nervous about getting the vaccine, you can tell them, at the end of the day, we have safety measures in place. If you're not vaccinated, you have to wear the mask. You have to still socially distance in some places. We can do a variety of things to allow you to be safe in the workplace. If there's a specific reason why the safety issues don't work, they can explain those to you. But fear of COVID or fear of the vaccine is not a proper claim by an employee. In fact, it's not defensible at all by them to be able to claim they have fear. Now, it may cause the fear of the vaccine or the fear of catching COVID may add to anxiety, which is a disability. But if they just claim, look, I'm afraid, or I don't think the vaccine is safe, that's not enough. So if the employee, indicates they're nervous again about contracting it, determine if there's other factors that they need to stay home about. Now, a lot of people have gotten used to being home to take care of children, to take care of elderly parents. There's a variety of reasons that they're now enjoying being home and doing their work at the same time. But at the end of the day, that's not a disability-related inquiry. It is an issue about having convenience, which I understand. But before the pandemic, they had those issues, and those issues will be there after the pandemic. And review any medical documentation you have, and then talk about the job description and the on-site work requirements and why you're requiring the person to come in. And at the end, you need to conclude it. So you have to say, is there any other concerns you have you'd like to talk about? Thank them for meeting with you. Let them know the next steps. Many employers don't close it out and tell them what's going to happen. And if you tell them I'm going to get back to you in 24 hours, get back to them in 24 hours. Most cases I see come out of poor communication between management and the employee. It's not the message that you're delivering, it's the fact that you don't deliver it or that you never round back and talk to people. Many times, if you're just communicating with folks and you let them know why you're doing what you're doing, they may not like it, but they'll agree to it and they'll move forward, or they'll leave. They don't have to stay, but many times if you talk through why you're doing what you're doing, it's going to be okay. And then you have to determine, and the last step is, what's the appropriate accommodation? You need to choose the most effective option for the employee, inform the employee, why you're doing it. And then, establish if you're going to bring them back for in-office attendance, tell them when they have to be back. And if they refuse and they're not eligible under the ADA or the FMLA, and you don't have any other issues, you may have to put them through some progressive discipline at this point, and that may include termination of employment. I've had a number of clients over the last several months that have been terminating employees that won't come back. And they've gone through this interactive process I just took you through. And if the employee just simply says, I'm afraid and I don't want to come back, but they don't have any of the other things that check the boxes, that's a problem for them from a legal standpoint. But if continued teleworking is necessary, I would have the employee sign a teleworking agreement and set specific dates for revisiting the arrangement you have. I like putting things in writing, and I think most folks like to have it. Most juries, when you're in front of a jury, and hopefully you never will be, I happen to be in front of them often, they want to see documented paper. They want to see things that you've given to the employee, and they want to see that you've been fair. And putting together a teleworking arrangement, having good notes of your interactive conversation, all of that is good for you. So let's move to our next topic, which is going to be the vaccines. So I will tell you, and this is not a political statement, none of the stuff I'm going to talk about vaccines have to do with politics. This all has to do with science. And so I'm going to recommend a resource to you. And you may bristle at it, depending on where you are on the political spectrum, but don't bristle. I'm just giving you a resource. The New York Times has a wonderful section on COVID-19. I would submit to you it's worth the subscription. It's a cheap subscription. I would get the subscription to the New York Times for this alone, because the pandemic coverage they have been giving from the start has been outstanding. They have a whole COVID section where you can plug in your county where you live, and they'll give you the COVID stats. Their articles are outstanding. So I don't usually push for a media publication. I'm not pushing it for any other reason, but for you to get good information. You may not like anything else in the New York Times, but I can tell you the vaccine coverage is outstanding. So I'm going to put that little plug, and I don't represent the New York Times in any way, shape, or form. So I'm just letting you know, I'm just doing it because I like it as a resource. So back in June, when I put this material together, and this is, probably hasn't changed a whole lot. There's a study that's been put together by Gallup that about 3/4 of the U.S. adults, plan to be vaccinated. Now, that's probably changed since the Delta variant's taken off. This study dealt with the fact that people were going to get vaccinated. Some had been vaccinated, but it's just the folks that are now getting to the point of believing they should be. So as of June 7th, 64% were vaccinated. I think we got close to 70 by July 4th. If I remember our stats right, we didn't hit exactly the number President Biden wanted to hit, but the study that I'm giving you, and you can see it here if you want to look it up, says that we're moving toward getting about 76% of the folks vaccinated. Among those that claim they're not going to get vaccinated, 78% of those folks say they're not going to reconsider their plan. That's disturbing in a lot of ways. And my hope is that with the variant that's raging in different parts of the country, that some folks will change their mind, but you have folks out there that absolutely won't change their mind. The next question we've been dealing with, and I have a blast that I send out to my clients. If anybody wants to be on it, you can email me and I'll put you on it. I do about a monthly short labor and employment email to folks. And over the last couple months, even before I started writing this, I said, look for there to be a real push for mandatory vaccines. You're now seeing it over the last 10 days. That's been in the news. You will see more of it. And I don't have any inside track to it other than logic. I think you're going to see tax breaks be given to employers and a push for employers to force employees or to mandate vaccines or be terminated from employment. I think that's where we're headed, because we can't get there without having the employers probably push it. Back in December, Dr. Fauci actually forecasted where we were going to be dealing with this, and he said, he needed 75 to 80% of folks to be vaccinated for us to hit the herd immunity. He was hoping that would happen by the end of the second quarter of this year. That would have been the end of June. That didn't happen, but he's hoping by the summer, and this is in December, he said by the end of the summer, we should have enough herd immunity. I don't think we're going to be there by the end of the summer. End of the summer is Labor Day. I don't see that happening in the next month because we're falling short of it. So that's where the mandatory piece is really going to get pushed. So requiring, people to be vaccinated has some legal and ethical considerations. Even though it's legal and employers can do it, you absolutely can mandate that an employee be vaccinated. If they're not, you can fire them. And if the only two exemptions they have are a religious exemption and a disability exemption, but most people don't fall within these categories. And so if you just have an employee that says, I don't like the vaccine, I don't believe in it, I don't like the emergency aspect of it, and they don't have a religious or disability related reason for an exemption, you then as an employer can mandate they be vaccinated. The Delta strain is an odd strain. We don't know how that's going to work. We don't know if the people that are vaccinated are going to have issues with it because we don't know. So you as the employer can make that decision. If you don't want to do a mandatory vaccine, then you can absolutely make people use PPE like a face mask. And in fact, in Virginia, it's required. The Virginia Occupational Safety and Health part of Virginia, which is Virginia's OSHA piece, the branch of OSHA, requires that if you're not vaccinated, you must wear a face mask in the workplace. That has not changed. So for the people that have relaxed that requirement, For the people that are not vaccinated, you're violating Virginia law. You might not get caught, but just like when you're speeding out on the highway, I'm sure none of you do, but when you're speeding, sometimes you get away with it, sometimes you get caught. People turn people into VOSH all the time. So just be careful. I'm letting you know what the law is. I can't make you comply with it. Employees with disabilities under the ADA can get an exemption from the mandatory vaccine requirement, but if the employee's disability under the ADA prevents them from receiving the vaccine and the employer does not have a way to reasonably accommodate them, you don't have to do the same reasonable accommodation analysis that you normally have to do. So if there's no accommodation available, or the accommodation would create an undue hardship for the employer, or the employee poses a direct threat to health and safety, you don't have to allow them to stay in the workplace. And this is a different aspect. When you're in the middle of a pandemic, employers have more leeway to put in the direct health issue and to be able to say it's an undue hardship on us to allow somebody with a disability to stay in the workplace if they're not vaccinated or they're not willing to do the protective measures that we're giving them. We're going to see probably some litigation over this, but I would again push the employers to have a interactive conversation with the folks with the disability and see why we can't work through an accommodation. Most of the time with wearing the mask and socially distancing, you should be able to have a safe workplace, even with a disability. That should not be an issue. But it's not always true, so I wanted to put that in there. So here's what you look at if somebody's going to be a direct threat. You know, what's the duration of the risk? Well, we don't know with COVID-19 because we now have a Delta variant. I don't know when we're going to get the Echo variant or the Foxtrot, since we only are using Greek letters now for these variants. I don't know, and Greek names, I don't know what we're doing. So I'm kind of using the old radio code that we used when I was in ROTC. It's still out there, so I think we're probably going to call the next one. It won't be Echo, I don't think. I think that sounds kind of strange, but we'll see. The E variant or the F variant. So we look at a couple things. What's the duration of the risk? We're going to have COVID around for a while. Remember, COVID is nothing more than a simple cold virus. This one has mutated to be something much worse. We've had COVID around for many, many thousands of years. But a COVID-19, the strain we have is a deadly one, obviously. Most of the time, we don't have a deadly issue with COVID. It's just a cold. But we're going to look at the duration of the COVID risk having to do with this type of a pandemic, the nature and severity of the harm. So what you're looking at in your workplace is, do I have people that are, immune compromised? Do I have people that if they get this, it's going to put them in the hospital? You have to balance all that when you're looking at direct threat. You know, that's the potential of harm's going to occur and the imminence of potential harm. It's going to be awfully hard for you as the employer to figure out the imminence of potential harm because we don't know. We don't know if somebody who in your workplace is vaccinated and is diabetic and may have COPD, whether or not somebody unvaccinated in your workplace gives them COVID, how are they going to react? We've been told by the experts, if you're vaccinated, you're not going to die from this. That's not necessarily true. People die all the time from the flu, and some people are dying that have been vaccinated with COVID. So, they said, look, most of the people, 99% of the people, they've been saying, if you get COVID and you've been vaccinated, you will not be on a ventilator and you will not die. Well, there's a 1% factor in there where some people do, and it's already happened. So you can't really, it's hard for you as the employer to look at the imminence of that harm, but you do have to factor it in when you're looking at direct threat. We then look at whether or not there's a reasonable accommodation that we can put in place to allow somebody with a disability to continue to work in the workplace, even though they can't take the vaccine if it's mandated by the employer. Most employers don't want to mandate it, but we're seeing a move toward it. Probably in the last 2 weeks, I've had 20 to 25 employers shift from a voluntary, we hope you get vaccinated, to a we're going to make you get vaccinated scenario. That's probably going to increase. So if that continues to increase, the pushback's going to happen from employees. Some are going to quit. Some will file a lawsuit. Who knows? But we're going to see more and more employers do this. So let's take a look at the case. There's only been one reported case. We'll probably have a couple more. This is a case out of Houston. This is Bridges versus Houston Methodist Hospital. And this was Miss Bridges and a bunch of nurses got together. That's why it says Bridges et al., which means Bridges and a whole lot of other people. And they were mainly nurses and other people working for the hospital, got together to fight the mandatory vaccination requirement by Houston Methodist Hospital. They filed their lawsuit. Houston Methodist filed a motion to dismiss. And the issue before the court is, can an employer require employees to be vaccinated? against COVID-19? The answer is yes. And here are the facts. On April 1st of 2021, Houston Methodist announced their policies that everybody have to be vaccinated by June 7th of 2021 at the expense of the hospital would pay for it. But if you wanted to keep your job, you had to do it. Miss Bridges and 116 other people sued to block the policy. The hospital moved to dismiss it, and the court dismissed it. And the court said, we looked at both arguments. So the court looked at what Miss Bridges was claiming. Miss Bridges claimed, look, I think these vaccines are experimental. I think they're dangerous. She had no evidence of whether they were dangerous, but that was what she said in her papers, and claimed they were experimental, and the court disagreed, said her contention was false. She claims that if she gets fired for refusing, she would somehow be the victim of wrongful termination. The court said, no, you would not be. And on May 28th of 2021, the Equal Employment Opportunity Commission determined that employers can require vaccinations for their employees as long as you give an exemption for a sincere religious belief, and for disabilities. We're not going to get into the religious belief piece of this, but I can tell you it's difficult for you to claim a sincere religious belief depending on which religion you're in. So for a Methodist, for them to try to claim, if you're Methodist, because I am, I can tell you that John Wesley, the founder of our religion, was a big push on medical science and on vaccinations. So, it's going to be difficult for you to claim the tenet of the Methodist religion is that you shouldn't be vaccinated. In fact, it's the opposite. But there are religions out there that probably do ban vaccinations and so forth, but that could be a tenet of your genuine religious belief, but that can be challenged by the employer. Be careful getting into challenging religious issues. That's beyond the scope of what we're going to talk about today. But I do a lot of religious litigation, discrimination, those types of things. We'll talk about that another time, but that's not for today. Bridges claimed that if she was forced to get the vaccine, it would violate federal policy because the vaccines had only been approved for emergency use. The court said no, that didn't matter either. It was nonsense. If the FDA has approved them, it doesn't matter if they're emergency use or regular use. The fact is they're approved. They would not have approved something that's dangerous. She then claims if she was coerced to do it and take the vaccine, that they're requiring her to do something that's not right, and basically the court said you have a choice. If you want to keep your job, you can leave, and if you don't want to take it, you don't have to be employed. And that's how the case ended. So they're maybe potentially going to appeal it. They'll continue to lose that case even on appeal. Employers do have a right to keep the workplace safe, and the employers absolutely can mandate a vaccine in the middle of a pandemic. It never ceases to amaze me, to be very frank with you, that folks, will say, hey, gee, polio needed to be eradicated. When I have that discussion with people, I said, how did you think polio went away? And they said, well, it just naturally went away. I said, it did not. It went away because of vaccines. There was a vaccine for polio. That's how polio went away. But for some reason, people don't believe that the vaccine this time should be implemented. And I think we're going to see more and more people get vaccinated, because I think that's where we're going to go. All right, let's talk about our last topic before we get to the poll and some questions. This is a case study on essential functions of the job and what we call fitness for duty exams under the ADA. This is a case out of this court, right where we are. We're in the Fourth Circuit Court of Appeals. So the way federal courts work is you have district courts or trial courts. The Fourth Circuit is the appellate court right between the Supreme Court and the trial court. So your last stop before you get to the United States Supreme Court, if you live in Virginia, is the Fourth Circuit Court of Appeals in a federal case. And so in this case, the Equal Employment Opportunity Commission sued McLeod Health on behalf of an employee. And so the issue before the court was this one. Is summary judgment for the employer proper, where an employee was forced to undergo a fitness for duty exam despite the lack of objective evidence that such exam was necessary? And was the employee fired on the basis of her disability? Now, I can tell you what summary judgment means is that's the last step before you go to trial. In federal court, if you've done all of your work in a case and you've done all the depositions, you've taken all the statements, you've gotten all the documentary evidence, right before you go to trial, you can file a motion for summary judgment saying to the judge, look, as a matter of law, we win. The facts are such that there's no real dispute. There's no genuine issue of material fact for a jury to even hear. And so as a matter of law, judge, you can throw this case out. And that's what McLeod Health did. What they did is they said, look, we've gone through all the processes here. We believe that summary judgment is appropriate. And the district court, the trial court, agreed. they granted summary judgment and threw the case out on behalf of the employee. And when the appellate court got it, the appellate court said, no, we don't agree. We believe the trial court made a mistake, and so we're going to reverse this case and send it back to the trial court to have a trial. And so that's what happened. But let's talk about the facts of the case, and you'll see why a trial was deserved in this case. Ms. Whitten was a 28-year employee of this company, and she was the editor of the employee newsletter. And so she would travel to the various facilities in South Carolina where these folks are located to interview folks. Now, she was born with post-axial hypoplasia of the lower extremity. So she had shorter bones in her legs and her arms. My sister-in-law suffers from this as well. So she struggled with her mobility. She got tired more easily than other folks. She can't stand or sit very long, but she had really decent evaluations, performance evaluations for 28 years. Swindler, I love that name. If you're going to be a villain manager in a case and you have the last name of Swindler, that's a great name. So, and I'm not making fun of the poor lady that has that last name, but I thought it was kind of interesting. I guess I am making fun of her. So, but her manager expressed concern. And she told HR, Swindler told HR that Ms. Whitten had been missing deadlines, arriving late at work, had a bad attitude, and really wanted her to go through a process. She said she looked sluggish, she looked winded, she appeared having difficulty staying alert. So she met with Ms. Whitten to address her performance issue and talked about her workload, and said, look, we really need to get your expectations down. There was no mention of her health. In 2012, Ms. Whitten had fallen 3 times in a 4-month period. After the third fall, HR told Swindler to report it to their occupational health folks, and so she did. So occupational health then wanted Ms. Whitten to undergo a fitness for duty exam, and that exam was not related to her job performance. This is a problem for employers. I'll flag it for you now. We'll get to it near the end of this slide, but you cannot do a fitness for duty exam if it's not related to job performance or business necessity. And they admitted it wasn't based on job performance. It was based on whether or not she could get around safely at the various locations to write her stories for the newsletter. Ms. Whitten did not believe that a fitness for duty exam was necessary since she'd only fallen once at work, but she felt like she had to comply to keep her job. The nurse practitioner that did the exam determined that she needed a functional capacity exam. These are done by a doctor, and they're designed to see whether you can perform your duties of your job. The nurse practitioner noted this was needed because of her self-reported history of falls, her decision not to use her cane, and the general lack of mobility and range of motion in her knees, ankles, and her feet. Ms. Whitten was paid on paid administrative leave. The occupational therapist that performed that exam did not have access to her prior exam to clarify the job duties. That's problematic for an employer. If you're going to make somebody go through this process, make sure that each step of the way that the medical folks have all the evidence they need to be able to determine what her job duties are so they can make a proper determination. That didn't happen here. McLeod told the occupational therapist that she needed to carry more than 20 pounds at a time. So they tested her for some reason to be able to carry 38 pounds at a time. It wasn't even true that she needed to carry 20, but they had a 20-pound lifting requirement in her job description. And I will tell you, when you're going through your job descriptions, make sure you look carefully at the lifting requirements. Many people do not have lifting requirements. Some jobs, absolutely. This is a white-collar job that more than likely did not have a 20-pound requirement, but was an old job description. Remember, she'd been there for 28 years. I dare say they probably ever updated her job description in the 28 years she was there. So 28 years ago, probably there could have been a 20-pound lifting restriction. 28 years ago, the computers probably weighed 20 pounds that we were lugging around if we had one to lug around at all. If you remember the laptop you may have had, and I remember having one in the mid-90s, that was a massive laptop. It had a huge battery. It did weigh about 12 to 15 pounds. We don't have that anymore. So the fact that they tested her on this was just wrong. The occupational therapist determined she was a high fall risk, recommended that she be restricted in her travel, not be more than 10 miles from the main office, and use a scooter, and provide curb parking for her. She asked for a new desk chair, which they gave her, but at the end of the day, they determined that she really couldn't get around. So after the occupational therapist made the recommendation, McLeod told her that she could not return back to her job because the proposed accommodations prevented her from traveling. To interview employees, and traveling and going to these various sites were an essential function of her job. Witten didn't agree. And she also didn't agree she needed to carry 20 pounds. But at the end of the day, that's what the employer decided that they were going to base this on. Witten did not dispute their findings. She did not apply to other jobs that were available for her within the system because they paid less than her editor job because she'd been doing it for so long. And they, after being on leave for 6 months, they fired her. And she sued. She went to the EEOC. She told them to file a charge, and then she ultimately sued. And the Fourth Circuit Court of Appeals agreed with her that summary judgment was inappropriate and she gets a jury trial. And the reason is the court said, look, if you're going to do a fitness for duty exam, we got to look and see if it's proper. This one wasn't proper. And under the ADA, to get one on an employee, you got to show it's job related and consistent with business necessity. To meet that standard, you've got to show there's objective evidence of the employee's ability to perform that job is impaired by a medical condition, or the medical condition poses a direct threat to her or others. Those are the requirements to do a medical exam. So I can tell you a good example of one where one would be necessary, and I had it happen last week. I had a client call me and say, look, we have a driver who we caught asleep in his truck on the side of the road at 64. And I said, okay. I said, we need to talk to him and find out what was wrong. It was in the middle of the day, middle of a shift. We found out from the employee that he has a sleep issue, and that when he feels drowsy and he has some narcolepsy, that he does pull his truck over so he can sleep. Well, we can't have him on the road. So we've got to determine, is a fitness for duty exam proper? It is in my example because it's job related. We can't have him crash his truck. It's consistent with our business necessity of making sure he's safe and he's doing his job by driving a truck. We're in the middle of doing that now for him. My hope is we can find something for him that will work just fine, some sort of medication, something like that, but we can't have him on the road if he's susceptible to going to sleep. That's not the issue we have here. In this case, the court said, that's not here. So we looked at what the requirements are, and then the court said, at the end of the day, it wasn't necessary for her to go to all these campus locations. The EEOC said, look, it's not an essential function of her job. It's preferred, but she does a lot of these telephone interviews and does a lot of things over the computer. And so the real issue for the jury is, is there enough evidence to set aside the employer's claim, or does the jury need to decide whether or not the employer treated her fairly? And what the court said is there's enough here for the jury to really take this case on. The evidence, there was evidence to support McLeod's claim, but there was evidence to support Witten's claim. She admitted in her deposition that her job required her to safely navigate the various campuses, but the EEOC said, that's not really a requirement. She really didn't have to do it, and let the jury decide that issue. Now, where I take exception with the EEOC is that the employer gets to set the requirement. The problem here is that the employer had shifting evidence on this issue. There was evidence in the case where people had testified that she could do the job remotely. She didn't necessarily have to go on campus. And she could conduct those interviews over the phone and get the newsletter out. So that was a jury question as to whether that really was an essential function of the job. The Fourth Circuit then looked at whether or not she had enough to file a lawsuit for disability discrimination. And the court said, here's what she has to show. She has a disability. She was a qualified individual with a disability, meaning she was performing her job. Her employer discharged her because of her disability. She was able to show all three. And the court said, look, that gets to go back and let the jury decide whether or not she meets this case. And they said, even if she wasn't a qualified individual, the problem is they made that determination based on an improper medical exam. And if they're using an improper medical exam to make the decision, that could be a disability discrimination inquiry that the jury gets to decide. So what did we learn from McLeod? Well, first of all, if you're going to do fitness for duty exams, they got to be job related and consistent with business necessity. In order to meet that standard, you have to have objective evidence that the employee's ability to perform that job is impaired by that medical condition or poses a direct threat to her safety or safety of others. Remember my sleepy truck driver example. That tells you exactly what you need to know. If it doesn't fit the sleepy truck driver example, you probably do not have a basis for a fitness for duty exam. I hear employers probably 3-4 times a month call me and say, hey, I want to do a fitness for duty exam on this employee, and start giving me a bunch of rationale for it. For the most part, we rarely will counsel them to do it. Essential functions of your job must be true. If it's not an essential function of the job, and in this case, it wasn't essential for her to travel to the campuses, it was a preferred job, but not essential. So at the end of the day, we're going to see more of those issues get challenged after the pandemic or during the pandemic as to whether or not on-site work is an essential function of the job or not. So that's one of the big reasons we did this seminar. I think we've come to the end, right about exactly where I wanted to end, which is good. So I think I'm going to turn it over. I think we have some poll questions, and then I can answer some questions if you have some.
Sounds great. Yeah, thanks, Steve. We're going to do a couple of quick poll questions. We've poll questions, and then we've got some really good questions in the from the audience. So we'll jump into those. And there's a wide range of wide spectrum of responses, but pick the one that closely matches. So the first one relates to your environment. My company has fully returned to work. My company has scheduled a return to work. My company has not scheduled a return to work, or it's not applicable. I'm going to give you just a few seconds to throw your responses in. All right, let's go ahead and show the responses. I've got, I don't know if it's coming up or not, but I do see 19% says my company is fully returned, 48% has scheduled return, and 22% has not scheduled return, and 11 is not applicable. All right, the next question relates to your environment and what's going to be expected of your employer. So my company wants me to be in the office, I would say most all the time. My company has a hybrid split of some kind, so work from home, teleworking, but definitely an expectation to be in the office as needed. And my company plans to close the office entirely because we're going fully remote or not applicable. Give folks a few seconds to respond. All right. So I see 17% says my company wants me to be in the office most of the time. 76% will go to, or have, will have a hybrid model. And then let's see. All right. And then we've gone to the last polling question here about the job description. So revise my job. Your company has revised the job description to require on-site work. Or revised my job description to require some on-site work, or has not revised my job description, or not applicable. All right, and I'm going to give just a couple more seconds here because it's in the 80%, 80+% has not revised my job description. So that back to your comments earlier, Steve. Looks like some employers have a little bit of work to do. All right, so thanks for participating in the poll. And the first question I have, Steve, is what if you have an at-risk person at home? Would the fear of COVID stand then? How would the employer address that?
Unfortunately, the at-risk person at home you likely had before the pandemic. If that's not true, but most of the time that's what I'm hearing is they had the same person at home. It doesn't have any impact. I'm not saying it shouldn't, but legally has no impact as to whether or not the employee can come to work or not. And that's where the employer can be somewhat sympathetic and empathetic with that. They absolutely can work with them, but from a legal standpoint, the employee does not have a legal claim to be able to say, look, I'm concerned about it. I don't want to bring COVID back home. I want to stay home and continue to work. That fear is not enough to be able to keep you home.
Gotcha. Okay. All right, thanks. A question here, you've already answered this, but I'm just put it up there again. Can you require people to get vaccinated? I think you clearly indicated that employers can require people to get vaccinated. Are we still required to provide COVID training to new employees?
COVID training based on VOSH, that requirement has been relaxed a little bit. It depends on which training you're talking about. So if it's full-blown COVID training about safety in the workplace, that's been reduced a little bit. It depends on, though, if you're in the healthcare industry. That's still a predominant piece you have to do the training on. It's part of your safety package. If you're in a less restrictive piece of it, it's not as stringent. I'm telling all the clients right now to continue it, just from a common sense standpoint, just to get people kind of trained on when to wear the mask, and if you have to wear it if you're not vaccinated, and so forth, and then what types of safety issues you want to have in the workplace. If you're ill, stay home. That's been my mantra now for, good Lord, I've been in the workplace, I can't even remember how many years. And I've been always telling people, don't bring germs to the workplace. So yes, I believe you still have some of that, but I think some of it's been relaxed.
Gotcha. Okay. Thanks, Steve. Next question, and I may tag on to this question because it was one that I had jotted down well. What about employees who claim both a religious and disability exemption for a reason to not wear face masks and a reason to not get their vaccine? And what I would add on to that question is, what evidence would an employee need to provide for either of those exemptions, if any?
So a couple. There's very little evidence. In fact, I've seen none. I'm not saying there's not any, because I'll never tell you there's not any. But I've not seen any evidence yet from any doctor. I've not read any publication that says you cannot wear a face covering. It doesn't matter if you have COPD. I've seen numerous people that have a variety of breathing ailments that a face covering does not cause that issue. There's numerous studies that show that the oxygen level coming in is the same. So from that standpoint, you can push back on that depending on who you got that from a doctor. And so you don't have to allow that employee, again, if they're claiming they have a disability, you can contest that. Whether or not you want to contest that or not, but I would contest that based on the scientific research that's out there. There really is nothing out there to stop it, but doctors are writing up those orders. So you can go back and actually contest that part of that with the doctor and ask that the employee either go see one of your doctors. You can push back on that if you want. On the religious piece of it, it's got a little bit more complicated piece. As I alluded to earlier, because I'm Methodist and I was alluding to the fact that the Methodist religion is pro-vaccination. No matter what you'll hear people say, that you're not going to be able to claim that if you're Methodist, you have a religious basis. You don't have a sincere religious belief. Where this starts to break down on the religious side is, can you contest their sincere religious belief? If you cannot, and you believe, and they do meet the sincere religious belief part, is it an undue hardship under the religious part of this to reasonably accommodate them? Here's where it's confusing. Under Title VII, there's the religious discrimination piece, and there's a reasonable accommodation that is nowhere near as strong as the reasonable accommodation branch under the ADA. So it's a much easier standard for an employer to be able to claim under the religious exemption that it's not a reasonable accommodation for you to, number one, not wear protect or not get a vaccine or not wear protective gear, whatever it is. It's a much easier standard for the employer to meet. I'm not telling you to violate people's religious beliefs. If you can accommodate them, you should, but the analysis is different. So the evidence that you're going to need from that employee is medical information as to the mask wearing to see if it's even valid. And then you're going to need more stuff on the sincere religious belief from that employee so you can actually test it. Again, it gets sticky when you get into these things, but at the end of the day, you get to keep your workplace safe. And if folks are not going to come back into work and keep it safe, then you have to go to the other option, which is whether they're going to stay employed. We hope we can make it work.
Okay. All right. Next question, Steve. If my company's formal job description does not state to work in the office or remote, does it need to be revised?
Should be. May not need to be, but I would encourage you to do it. Most people don't have job descriptions that say that attendance at the work site is an essential function. I've been pushing that for years. Nobody's really listened. They are now. But I've been saying, look, attendance needs to be really outlined about where the attendance needs to take place. You're able to, as an employer, to say, look, I need you to be at the work site. If it's vague or not even in the job description, you can say, look, I need you here. If the employee pushes back and says, so tell me where that's an essential function. I've been doing this job for 16 months, not at your work site. I would revise that job description and just make it clear.
Gotcha. Okay. All right. So that's all the questions I have in the question box. Taking the last check here. Last thing for you, Steve, before we wrap up, maybe a little bit of a prediction question. And I've been reading a bit about more and more about the lack of accessibility in remote and hybrid working for hard of hearing or deaf individuals. One article stated the bulk of employers have failed to provide enough of the accessibility tools required for communication between its hard of hearing and hearing staff in remote working setups. And, you know, I'm curious, again, more of a prediction question, but, you know, do you think we'll see an uptick in ADA related cases as a result of what was or was not done for employees during the pandemic, or do you see employers maybe, you know, adopting universal design for all employees?
I think you're going to see an uptick for a variety of reasons. I think the ADA is one of the main laws that the EEOC and the Biden administration wants to push. Contrary to popular belief, it was the same law that the Trump administration wanted to push. The Trump administration had more charges of discrimination that they investigated than the Obama administration did. And people are going to say, oh, that can't be possible. It was very possible. It happens like that quite often. When you have a Republican that's the president, many of the people that work in the government are either moderates or Democrats. And so they think it's more of their responsibility to do more investigative work when a Republican's in office. So you will see more laws and more investigations on the employment side happen. I'm not saying the Democrats do a bad job, so please don't take it like that. You're going to see plenty. But the EEOC is now set up with three commissioners that are Democrat, 2 that are Republican because the president is a Democrat. We will see more of these cases brought by the EEOC under the ADA. I agree with you on the hearing impaired issue. This has been a problem throughout the pandemic. We've been addressing for a number of my clients. We've been putting in a number of things that are reasonably accommodating the hearing impaired, but it's not enough. And I can see where a number of those cases are probably going to be coming up. There's been several charges already filed that I know of against some of my clients. So I know we're going to see an uptick in that litigation.
Great. Well, thank you. We are at the end. We've got 1 minute left. Steve, thanks so much for presenting in our annual ADA legal update in this post-pandemic age, which we're not quite post yet. But thank you for joining us today. To our audience, thank you for your participation and your questions and your active attendance. Steve mentioned earlier, you can send him an email to get on his mailing list, which I would highly encourage. And we will be sending out the presentation right after this webinar, and then the video will be available in a couple of days. We'll post that to our website and to LinkedIn. So thanks again. Thanks to our interpreters, and I hope everyone has a great day.
Take care, everybody. Thank you.